Good morning, Mr. Sarmiento.
Ese señor Sarmiento.
You
Bien, señor Sarmiento.
Buenos días.
were charged with criminal trespass. You are facing up to 6 months in jail and/or a $2,000 fine.
Welcome back to another explosive courtroom session where justice meets reality. Today we've got not one, not two, but 3 cases that will blow your mind. First up, a criminal trespass charge involving a stolen vehicle with a twist that has a judge absolutely baffled. Then we're diving into a burglary case where the defendant has been playing hopscotch across state lines picking up charges. And finally, buckle up for a case that's been dragging on for over 800 days with a defendant who just can't seem to get together, and a judge who's absolutely done with the excuses. We're talking damaged steering columns, screwdrivers as evidence, immigration warnings, and a lawyer who's gone above and beyond only to be let down repeatedly. The courtroom drama is about to get real, so stick around because you won't believe how these cases unfold.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge.
We're going to go slow.
Yes, Judge. On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know. He didn't say he know he's stolen. He just didn't know him. Did not give permission.
You're telling me that he's in a car, he doesn't know the driver, and
Right. The complainant just said that in regard, he did not know the defendant, did not give.
I understand that. I get that, but so he's a passenger in a car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey man,
Hold up. Let's break down what's happening here because this case is already getting wild. The prosecution is charging this defendant with criminal trespass because he was a passenger in a stolen vehicle. But here's where the judge starts poking holes in the case. How would the passenger even know the car was stolen? The prosecutor is saying the vehicle owner doesn't know the defendant and didn't give him permission to be in the car, but the judge is rightfully confused. If the defendant was just a passenger and doesn't even know the driver, how is he supposed to know the car is stolen? Criminal trespass is what's called a specific intent crime, meaning the defendant has to knowingly and intentionally enter or remain in a place without permission. The judge is essentially saying, you can't charge someone with criminal trespass if they had no reason to believe they were doing anything wrong. This is a fundamental legal principle. You can't just be guilty by association. The judge is visibly frustrated, saying she's beside herself. Try to understand how this charge makes sense. The prosecution is going to have to come up with something concrete to prove the defendant knew the vehicle was stolen, or this case is going to fall apart. What do you think? Should passengers be held responsible when they have no idea they're in a stolen car? Let me know in the comments.
So the trespass was the driver driving into the area and he was the defendant.
He's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
Tuvo un caso.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that it's a specific intent crime. You have to, there's got to, in my opinion, you've got to somehow know that the car is stolen.
And Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was, one moment,
A scratch on the hood.
signs of theft that would lead a reasonable prudent person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. I thought you also said that the driver and.
No, Your Honor, and it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
So there is enough there that a reasonable person would believe
That
he's in a stolen car.
Yes.
So the steering column, was it?
was broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
Okay, now we're getting somewhere. The prosecution just dropped a critical piece of information that completely changes the case. Turns out the defendant was actually in a relationship with the driver of the stolen vehicle, and here's the kicker. The steering column was broken, and there was a screwdriver stuck in the ignition that was the only way to turn the car on. That screwdriver was tagged into evidence, meaning there's physical proof that the vehicle had been tampered with. The prosecution is arguing that any reasonable person sitting in a car with a broken steering column and a screwdriver in the ignition would know something was seriously wrong. And honestly, they might have a point. If you're in a relationship with the driver and you see the car is being started with a screwdriver instead of key, that's a pretty massive red flag that the vehicle is stolen. But here's where it gets interesting. The judge is still skeptical. She's about to tell a story about being young and driving around in beat-up Jeeps that were always jimmy-rigged and broken down. Her point? Not every damaged or rigged vehicle is stolen. Sometimes people just drive junky cars. This is fascinating because it shows how judges think through these cases. They're not just looking at the facts on paper. They're considering real-world context and whether a reasonable person would actually know they were in a stolen car. Do you think the defendant should have known? Or is the judge right to be cautious? Drop your thoughts below.
Un desarmador podía apagar el vehículo.
See, I don't know, because when I was young and dumb and 17, and, my friend had a CJ7, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
yes.
always broke down. They always had a problem. We always, Jimmy rigged it as well,
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
No difference.
That goes to the element of for the criminal trespass, it goes to with knowledge that it was,
Reconocimiento
No, I'm sorry. I'm going to find no probable cause. I'm sorry.
porque no hay razón probatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir.
Wow. The judge just made a massive ruling and then dropped some serious real-world advice. Let's break this down. Despite the prosecution's arguments about the broken steering column, the screwdriver evidence, and the defendant being in a relationship with the driver, the judge found no probable cause. That means she doesn't believe there's enough evidence to prove the defendant knowingly committed criminal trespass. This is huge. The judge essentially said that just because the car had a damaged steering column doesn't automatically mean the passenger knew it was stolen. Maybe it was just a beat-up car, like those old Jeeps she mentioned. Without clear proof that the defendant had actual knowledge the vehicle was stolen, the charge can't stand. But then the judge delivered a stark warning that everyone needs to hear. When you hang with dogs, you get fleas. She's telling the defendant that even though he's being released, he needs to be extremely careful about who he associates with. And here's the critical part. She warned him about immigration consequences. If he's not in the country legally and gets arrested again, even spending just 4 hours in jail could trigger an immigration detainer, meaning he'd be stuck in custody until he's deported. This is real talk from a judge who's seen it all. The message is clear. Stay away from trouble. Choose your friends wisely and live clean. What do you think of the judge's ruling? Was she right to dismiss the case? Or should the defendant have been held responsible? Let me know.
Mr. Johnson, you were charged with burglary of a motor vehicle. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 22nd, 2023, officers were dispatched to a lawn management company at 630 Rankin Circle for a burglary in progress. The defendant and a co-defendant had cut through the fence surrounding the property and were searching through vehicles at the location. There are surveillance videos of the defendant and co-defendant inside a van on the property.
Can you run an NCIC on him? I'd like to know what, if anything, has happened from the time that he picked this case up to the time he's now back in front of us.
Yes, Judge.
I don't know, Mr. D. Guys, he has a warrant for now, and I don't know if I'm going to give him a PR bond. I want to see how he's been since September 23. If you've been on picking up cases like it's just left and right, then I don't know, man, but
Yes, sir, Your Honor.
my only concern is my community. That's all I care about, and I'm going to do everything in my power to protect my community. If you've just become a danger where you're hopscotching states and you're playing hopscotch and you're picking up cases while you're hopscotching, no. The revolving door closes.
So I do see on December 7th, 2023, the Georgia case theft by taking, but that's the only other case.
Is that a felony or was that a misdemeanor?
It's felony, Your Honor.
What was it? Do you have a disposition?
No, there's no disposition listed.
13 months per him, Judge.
Anything else he's picked up?
No, Your Honor.
This is where the judge takes control and shows exactly why her approach to justice is so important. She's dealing with a burglary of a motor vehicle case from September 2023, and before making any decisions, she's ordering a full background check, an NCIC search, to see what this defendant has been up to since he was originally charged. And what does she find? A felony theft case in Georgia from December 2023, just a few months after the burglary charge, with no disposition listed, meaning it's still pending 13 months later. The judge uses a perfect metaphor here, hopscotching states and picking up cases. She's describing defendants who commit crimes in one state, then move to another state and commit more crimes, essentially playing a game of criminal hopscotch across state lines. And here's what makes this judge so effective. She's completely transparent about her priorities. She flat out says, "My only concern is my community. That's all I care about, and I'm going to do everything in my power to protect my community." This isn't about being harsh for the sake of being harsh. It's about recognizing when someone is becoming a pattern offender and a danger to public safety. The judge is making it clear that if you're bouncing between states racking up charges, the revolving door is going to close. She's considering whether to give him a PR bond, a personal recognizance bond where he'd be released without paying anything. But she's hesitant because of this pattern of behavior. What's your take? Should repeat offenders who commit crimes across multiple states get another chance? Or is it time to close that revolving door?
I have the, oh man, I speak. All right, let's see.
I'm going to reinstate your bond now, but I'm not going to do it again. If you take flight on me again, I'm telling you, I'm going to make it high. No more PR bonds for you. You got a little kid in your charge, man. Be the good father that you should be. Teach them right, because they look on you for support and for them to do the right way. They see this. We don't need more. Know what I mean? Come on, man. Be better. I'm placing bond conditions on you now that you're not to go back to this location where this occurred and you're not to be in possession of weapons.
So,
Don't pick up any new cases. You've got a great lawyer here. Just listen to him. He'll take care of you. If I find that you're becoming a danger, you know what's going to happen. I don't have any tolerance. We have nothing but death and destruction on the news. I don't want any more. Do you understand? So, all right, man. Good luck. Don't leave until you sign the bond conditions. Okay.
Thank you.
That states bond conditions?
Yeah.
This is one of those moments that really shows the human side of the courtroom. Despite the defendant's criminal record, including burglary charges and a felony case in Georgia, the judge decides to reinstate his bond and give him one more chance. But she makes it absolutely crystal clear. This is the last chance. If he takes flight again or violates any conditions, she's going to set his bond so high he won't be able to afford it. No more PR bonds. Now here's what makes this moment so powerful. The judge brings up the fact that the defendant has a young child. She's appealing to him as a father, telling him to be better, to teach his kid right, because children look to their parents for guidance and support. The judge is essentially saying, your actions don't just affect you, they affect the next generation. What kind of example are you setting? She then lays out strict bond conditions. No return to the crime scene, no weapons, and absolutely no new cases. And then she drops a sobering line. We have nothing but death and destruction on the news. I don't want any more. This judge isn't just processing cases mechanically. She genuinely cares about reducing crime and violence in her community. She's giving this defendant an opportunity to turn his life around. But she's also making it clear that there are no more second chances after this one. The ball is entirely in his court now. Do you think this kind of tough but compassionate approach works? Or should judges be stricter with repeat offenders? Let me know what you think.
Your Honor, can you hear me, sir?
I can hear you. And let me tell you now that I really haven't seen a lawyer go above and beyond the call of duty as Bayoshi has done in this case. Everything and every time you have been back here is because of something that has happened, something that has failed to happen. The last time here, all you had to do was provide documentation that you could not afford whatever it was. You have failed to provide that documentation. As a result, they've now kicked you out of the program. I know that Bayoshi is going to give it one last shot as to whether he's able to either get the case dismissed, get you back in. I don't know. But I am now putting this baby to bed. So I will give you a week. Is that okay?
Yes, Your Honor. That should be enough time.
I am not waiving your appearance anymore. And in the next week, if he is unable to get you back into the program, if he is unable to get the case dismissed, you must either accept the plea bargain agreement from the state, or I will immediately set your case for trial, and it's going to be a very short trial setting. Do you understand?
I understand, sir.
It's unacceptable that we are now at 800 days, and they have literally over and over and over bent over backwards to help you. And if I were you, I would probably just, I can tell you now that Bayoshi's not very happy with you as well.
I'm not happy with myself too. And
So-
I don't have power over the old situation.
I don't want you to say anything. Don't say anything. There's nothing you need to say. The only thing that matters are actions. You telling us something it goes in one ear, it goes out the other ear. Because when you get out there, we still have issues. So I don't care. I'm giving Bayoshi a week to do what he can do. If it doesn't work out and it doesn't end up getting dismissed, you must be here in court. If you fail to appear, I'm going to revoke your bond. Do you understand?
I understand, sir.
Thank you, Your Honor.
Hold on. Before
Thank you, Your Honor.
I want to give him the date.
Oh, yep, you need to.
Don't go, because I want to give you the date so I can mark everything down so that you knew exactly what day and what time you had to be here.
Okay, sir. I'll be there.
What day do you want, if I was you?
Your Honor, we can literally do this time next week, the 24th.
If you need a little bit more, because I know how busy you are, I'm happy to give you an extra week if you want.
In 2 weeks' time, then that would be the 30th.
Yeah, but don't pick a Friday because Fridays are busiest with arraignments. So like perhaps like a Thursday or whatnot, you know?
Okay, I'll pick, okay,
You want that Thursday?
let me just double check that.
That would be
That would be Thursday, the 30th.
30th? You want to do that? And because of how great you have been, bios you that, but,
I appreciate you.
Yeah.
Yeah, Thursday, the 30th works.
all right.
Thank you. If you could,
You must be here January 30th. If the case is still active and it doesn't get dismissed, you must be here in person on that day and either accept the plea bargain from the state or we will immediately set it for trial. Do you understand?
Yes, sir. Thank you.
All right.
And that's a wrap on one of the most emotionally charged courtroom sessions we've seen in a while. Let's recap what just went down. In our third and final case, we witnessed a defendant whose case has been dragging on for a staggering 800 days. That's over 2 years. The judge made it abundantly clear that everyone involved, the court, the prosecution, and especially his lawyer, has bent over backwards to help this defendant. He was given opportunities to provide documentation to stay in a diversion program, but he failed to follow through, and as a result, he was kicked out of the program. The judge praised the defendant's attorney for going above and beyond the call of duty, doing everything possible to help his client. But now even the lawyer is frustrated. The judge laid down an ultimatum. The defendant has 1 week for his lawyer to try to get the case dismissed or get him back into the program. If that doesn't happen, he must appear in court on January 30th and either accept the plea bargain or go straight to trial. And the judge made it clear it would be a very short trial. When the defendant tried to make excuses, the judge shut him down immediately, saying, "I don't want you to say anything. The only thing that matters are actions. Words go in one ear and out the other." That's powerful. This case is a perfect example of how the justice system tries to help defendants turn their lives around. But at some point, there has to be accountability. If you found these cases as intense and thought-provoking as we did, make sure to smash that like button. Drop your thoughts in the comments about which case shocked you the most. And don't forget to subscribe for more incredible courtroom breakdowns that you won't find anywhere else. We'll see you in the next one.